I'd like to call today's meeting of the Interim Legislative Committee on Child Welfare and Juvenile Justice to order. We have our committee policy analyst, Mr. Guinan, here to take the roll. Mr. Guinan.
Thank you, Mr. Chair. For the record, Patrick Guinan. I'll start the roll now. Senator Cancella is absent, as we know. Senator Hammond. Assemblywoman Hanson.
Here.
Assemblywoman Monroe-Moreno.
Here.
Assemblywoman Torres.
Here.
Chair Orenshaw.
Present. And Mr. Guinan, please mark any other members present as they arrive. For the public who is listening via the help of our wonderful broadcast team at the Legislative Council Bureau, I want to just go over a few housekeeping measures before we get to agenda item number 2. Please be sure to mute your microphone when you're not speaking to minimize any background noise. Minutes of the meeting are produced in a summary format and are not verbatim. Meeting materials can be accessed on our committee's webpage. Anyone who would like to receive electronic notification of and access to this committee's agendas, minutes, and final report can do so by signing up on the Nevada Legislature's website. Our committee will be taking one vote today to approve the minutes of our previous meeting, and we will conduct that vote via a roll call vote. There will be a public comment period at the beginning of the meeting and at the end of the meeting, and that is limited to 3 minutes per speaker. The public may comment in 4 different ways, all of which are listed on the agenda. You can call the phone number, area code 669-900-6833, and enter the following meeting ID, 949-4036-8150. Otherwise, comments can be sent via email to childwelfare@lcb.state.nv.us, and child welfare juvenile are all together with no punctuation in between. You can mail comments via U.S. mail to the Legislative Council Bureau Research Division, 401 South Carson Street, Carson City, Nevada, 89701. And if you want to fax comments, you can fax them to the following fax number, 775-684-6600. With that, I'd like to go to agenda item number 2, public comment.
May the caller with the last 3 digits of 739 please press *6 to unmute yourself. Please slowly state and spell your name for the record. You have 3 minutes. Please begin. Once again, I will ask the caller with the last 3 digits of 739 to please press *6 on your phone now. Please slowly state and spell your name for the record. You have 3 minutes. Please begin.
Good morning. This is Joanna Jacob, Joanna Jac as in cat, O-B as in boy, on behalf of Clark County. Good morning, Chair Orenshaw and members of the committee. I just wanted to give comment this morning to alert you to a letter that we have filed, Chair, for review by the committee, responding to last meeting in August when Director Armstrong had testified about policy changes posing fiscal impacts to the state. We wanted to offer perspective from Clark County, the largest child welfare agency in the state, and we're asking the committee's support to review this letter and possibly consider a letter to the 21 legislature urging review of the issues we have outlined. We are facing some challenges heading into the 2021 legislative session due to a number of factors. I know that you are very familiar with the major shifts in the systems that are coming, delivering services to the youth and the family that we serve. This is a result of federal changes from the Family First Prevention and Services Act, as well as state changes, including SB 293 and the services that we will begin to deliver to children who are victim of commercial sexual exploitation. We understand that these changes are coming, but please understand also that Clark County is experiencing a structural budget deficit. We are losing $10 million in the loss of federal funding alone due to the shift in the way that our federal waiver under 4E was funded as we shift to the Family First Prevention and Services Act. As we enter into the 2021 legislative session, we are estimating our structural deficit to be $27 million in child welfare. And this is a particularly vulnerable time for the county, and we do not believe that we can maintain a deficit of that magnitude. We know that you've conducted a study over this interim period on how to draw down more federal dollars, and we support looking into that issue, but we also urge your review of the capped block grant that has been placed since 2011 in light of the significant policy changes that we have faced at the state and the county child welfare agencies since that system was put into place in 2011. So even with the challenges that we know the state is facing and the county certainly has faced as well, we have supported our frontline workers, and we will continue to do so. We want you to consider Clark County as a partner to the legislature, and we want to work with you in the forthcoming session to help to step up to continue to serve our community and the children and the families we serve. Our constituents are yours, and so we thank you for your work that you have done on these issues. We urge your review of the letter, and thank you for your time, Chair Orangehall.
Thank you very much, Ms. Jacob. And that letter, I believe, was posted on our committee's website for members and any members of the public to review. And it's good to have you here advocating on behalf of Southern Nevada. Northern Nevada's loss is Southern Nevada's gain. We're very lucky to have you and appreciate your hard work on these very difficult issues.
Thank you, Chair Orangehall. The public line is open and working. There are no additional callers at this time.
Thank you very much, Mr. Anderson. I would like to then move on to remind the public there will be an opportunity for public comment at the end of the meeting as well. So if you didn't get in at the beginning, there will be a period at the end of our agenda. I'd like to move on to agenda item number 3, approval of the minutes for the meeting on August the 28th, 2020. And if there's any question about the minutes, please feel free to bring that up now. Otherwise, I'd accept a motion.
I
I have a motion from Assemblywoman Torres. Is there a second?
A second. This is Assemblywoman Monroe Moreno.
Thank you, Vice Chair. We have a second from Vice Chair Monroe Moreno. Any discussion on the motion? All right, seeing no discussion, Mr. Guinan, I believe we're taking this vote by roll call.
That's correct. Thanks, Mr. Chair. Patrick Guinan for the record. So here we go with the roll call vote for approval of the minutes. Chair Orangehall,
Yes.
Assemblywoman Hanson,
Yes.
Vice Chair Monroe Moreno,
Yes.
Assemblywoman Torres.
Yes.
Thank you. That concludes the vote, Mr. Chair.
Thank you very much, Mr. Guinan, and please mark Senator Cancela and Senator Hammond excused. We're now going to move on to agenda item number 4. We have a presentation on a recommendation for a bill draft request concerning child welfare case disposition. And we do have a representative from the Clark County Department of Family Services. I think before we get into those agenda items 4 and 5, Mr. Guinan, are you able to briefly just kind of explain the process and those recommendations for bill drafts and what might be the potential outcome? You've worked so hard with this committee through the past.
Sure, Mr. Chair, I'd be glad to. Again, Patrick Guinan for the record. So in an ordinary interim period, we have an open window for a solicitation of recommendations to the committee, which we usually run around, say, the middle of June to the middle of July. But during this interim period, given all the difficult circumstances that the committee and the legislature has been dealing with, the chair reopened that submission period and kept it open until September 15th. So we received 3 recommendations at that later deadline, which hadn't been vetted by the committee, and we hadn't had any public testimony on those yet. So these agenda items today, the 2 that deal with direct file and one that we're about to hear, are recommendations that were submitted to the committee after we had our last meeting and before this meeting. So the point of these agenda items today is to have these issues publicly vetted by the committee. It does not guarantee that they will appear on our committee's final work session. As the members know and the public probably know, the content of the final work session document is up to the chair. So when we do our work session in October, the items appearing on that work session will be those that have been approved for the work session by the chair. They will include potentially any of these from today, others that we've had submitted to us during the course of testimony during the interim, and any generated by staff at the chair's direction that would be included on the work session for the committee's consideration. So I hope that makes everything clear, and I'd be happy to answer any questions, Mr. Chair.
I think that's really excellent. Thank you for explaining that, Mr. Guinan. And certainly, as I've had the privilege of serving on this committee in the past, I've seen that sometimes suggestions turn into bill draft requests, sometimes they turn into a memorandum, sometimes they become a letter to a particular agency or a particular department of government in terms of trying to change how things are handled. So recommendations don't always turn into bill draft requests. Sometimes they do, but sometimes they turn into memoranda or letters. So thank you again for going over that. With that, I would like to move on to agenda item number 4, where we've got a representative from the Clark County Department of Family Services. And I just want to advise the committee that as this agenda item relates to recommendations for a bill draft request made by the Clark County Department of Family Services, I would like to advise the committee that I am employed by Clark County as the Deputy Public Defender with the Clark County Office of the Public Defender in the Juvenile Division. I just wanted to advise the committee of that and turn it over to whoever would like to present from Department of Family Services.
Good morning, Chairwoman Shaw and members of the committee. Tim Birch, Administrator of Human Services for Clark County, Nevada. I am joined this morning by the Assistant Director of the Department of Family Services, Ms. Abigail Frierson. She will be doing the lion's share of the presentation. I'll turn the floor over to her, but I wanted to let you all know that I will be in queue to answer questions as the presentation goes as well. So, Abby.
Thank you very much. Good morning, Mr. Birch. Good morning, Ms. Frierson. Thank you for being here today.
Good morning. Abigail Frierson for the record. I wanted to start by saying I appreciate this opportunity to talk to you all, to talk to this committee about, I think, what would be a small change in the law would actually have a big impact in improving child safety across Nevada. So we're going to be talking about case dispositions. I want to explain a little bit about case dispositions. Then I'd like to talk a little bit about our process, and then I'd like to talk about the change that we're recommending. So to begin, I'm sure you guys all know that the committee all knows that the role of child welfare is to ensure the safety of children and in our community and the children that are in our purview. One of the most important ways that case dispositions are used to keep children safe are through intervention. First and foremost, it's those substantiations that actually give us the ability to intervene in families' lives. However, case dispositions also have another important aspect to keeping the community safe, and that's through future investigations and through the central registry. How case dispositions are used with future investigations, either through law enforcement or child welfare, is when an allegation comes in, well, they will review history. Both agencies will review history.
Ms. Frierson, excuse me, Mr. Chair. Ms. Frierson, if you could please reshare your screen. Your presentation went off.
Thank you. I apologize. I noticed that and I just thought, I wasn't sure. I thought it was intentional, but I'm not very good with technology. So actually now I see it. Thank you.
Okay, great. I'm so glad. Look, please let me know if that happens again. So when let me back up a little bit. When cases are received, when reports are received by the Child Welfare Agency, we have trained investigators that will go and assess those allegations. When we assess those allegations, our cases comes to a close with something called a case disposition, which is really an investigative finding. In Nevada, there are two options for those investigative findings. That's a substantiation or an unsubstantiation. Substantiation meaning that we met a burden of proof that that abuse or neglect occurred, and unsubstantiation being everything else that comes to the agency. As I said, those substantiations are particularly important for giving us the ability to intervene in families, but those unsubstantiations and substantiations also serve a very important role for community safety in that they're used for future investigations, and they're used in something called the Central Registry, which I'm sure you guys are all aware of, is a database of those case dispositions. Those are used by the Child Welfare Agency to determine who is appropriate for placement of children when they are removed from homes. They're used by schools to determine who can be teachers. They're used by daycares to show who should be around our children. They're even used to protect people working with the elderly. So these are very important case dispositions. And because they're so important, that's why it's so important that they be even more accurate as a way to give people more information about what our investigators did actually find when they went and vetted these allegations. So just briefly, just to orient you to the process, I just wanted to talk about what happens when a report comes into Child Welfare Agency. Initially, a report is made, and we have, in Clark County, we have individuals who are trained just to vet those reports when they come in. They come in and they screen them to see if they meet our statutory standard of child welfare or child abuse and neglect. They also vet them to ensure that we have jurisdiction over those allegations, meaning that those families are found within Clark County. And then they will make a screening decision. Once the screening decision is made, some cases will be dispositioned as information only, and some will be opened up for investigation. So to kind of give you an idea in Clark County of how many cases we're talking about here, our CPS agency received nearly 30,000 referrals, and in 2018 and 2019. In 2020, it was about 25,000. And that was, we think, is due to COVID-19 reducing the number of reports that we received in March and April and May. And you see that approximately 45% of those get screened in for investigation. So once those cases are screened in for investigation, we have an investigative process that we will go through that involves reading the report, talking to the reporting source if possible, going out, interviewing parents, children, any collaterals that are available, and making determinations about risk and safety as we go along. These safety assessments are all combined in a document we call the Nevada, in Clark County, we call the Nevada, we call the NEA. And after that, our case will be ended with a disposition. As I said before, there's only two options in Nevada. That would be an unsub or a sub, an unsubstantiation or a substantiation. All right, so I do want to define that a little bit. So basically a substantiation is when a report of child abuse or neglect was made to a child welfare agency, and the agency determines that there is reasonable cause to believe that abuse or neglect occurred and that the alleged perpetrator is responsible for the abuse and neglect. So essentially we have to prove two things. One, that abuse and neglect occurred and that the alleged perpetrator is responsible for that abuse and neglect. Everything else is unsubstantiated, okay? And I think what I really want to drive home is that there are a ton of reasons why cases could be unsubstantiated. If we're not able to locate families and assess those allegations, that must be unsubstantiated. If we know that abuse and neglect occurred, but we can't determine who did it, those must be unsubstantiated. If the report was completely false on its face and it was a case of mistaken identity and we're involved in the wrong family's lives, those cases must also be unsubstantiated. Because there's such a wide range of reasons why cases should be unsubstantiated, that unsubstantiated term kind of loses meaning, especially when future law enforcement and child welfare agencies are trying to determine whether their current case has merit. But also when we're talking about the central registry, it's important to know that all unsubstantiations are not created equally. So to kind of take this point home, of the 12,000 or so investigations that get opened, only about 2,500 actually meet the substantiated level. That's about 25% or so. That means 3/4 of our investigations are all getting dumped into this one big bucket of unsubstantiated, which doesn't give us enough information in case the family comes back in, which doesn't give the central registry enough information. The people accessing the central registry doesn't give them enough information to make informed decisions about whether these people should be around children or the elderly or vulnerable populations. So I wanted to show you a couple of different states examples. I have only looked at maybe 10 or so states. And I did want to point out that Nevada was the only state I found that only had 2 case disposition options. So as you can see, Nevada has substantiated and unsubstantiated. Texas has 5 disposition options, which is reason to believe, unable to determine, which is essentially that the investigation was completed, but it was inconclusive. Unable to complete, which is essentially we were unable to complete the investigation either because we were unable to find the family or the family moved before we could finish the investigation. Ruled out, which means that we did a full investigation, we found the allegations were not credible. And an administrative closure, which I really like that they have available for those families that really should have never had a case opened at all, as a way to show that there was a mistake made when whoever called it in. You'll see that New Hampshire has almost twice as many options. Founded court action, founded problem resolved, founded services only. So I think that would be that we would substantiate, but just because we substantiate doesn't mean we always go to court. It doesn't mean that they always need our services. Incomplete, I think, would be akin to the unable to complete that Texas has. Rebuttable presumption of harm, unfounded, and unfounded with reasonable concerns. And I would connect the unfounded with reasonable concerns to the unable to complete that Texas has available, which means that we were unable to get clarity on whether abuse or neglect occurred, but perhaps there were still some issues that were concerning. Here are some other examples. I want to point out that one of our closest neighbors, California, has the 3 options. They do offer the inconclusive. And then I'll just go and show you a state that has a lot of options available. I'll just give you a moment. So today we're proposing to amend NRS 432B 300 subsection 6 to add the following case disposition options. So we want to model our case dispositions after Texas and have the unsubstantiated, the substantiated, but also add in unable to determine, unable to complete, and an administrative closure option. How we would define unable to determine would be a report of suspected child abuse and or neglect was made to a child welfare agency for which the agency determines that there is some credible evidence that child abuse or neglect occurred, but the evidence is not sufficient to support a substantiation. So when this would be useful is if there was some concern, but we were unable to get across the substantiation line. I do want to point out that what makes child abuse and neglect investigations particularly difficult is that these are things that happen in secret. So often the only witnesses are the parents and the children. And depending on the child's developmental abilities or age, it's very difficult to sometimes determine what happened if there's no physical evidence one way or another. And as we learn more about the effects of trauma on memory, it is a challenge sometimes to be able to get clarity on what occurred to the standard that would support substantiation. We're proposing that unable to complete be defined as a report of child abuse and or neglect was made to a child welfare agency, and that the agency was unable to complete an investigation because either the child welfare agency lacks necessary information, such as a current address, the family was contacted and then moved and could no longer be located to complete the investigation, or the family refuses to cooperate with the investigation or appears to be avoiding CPS intervention, and the agency has insufficient evidence to proceed after exhausting all legal remedies. So essentially, these are the families who we're unable to locate or who disappear before we can finish our assessment, or just reject our intervention and we've gotten to the end of the road of our legal remedies and we still have been unable to complete our investigation. For instance, CPS can't just interview children necessarily or go into people's homes without a proper legal basis. So there's some allegations that we're not able to fully vet if the family is unwilling to cooperate. And finally, for the cases of mistaken identity or for the reports that never should have been open, we'd like to have an administrative closure option. So these would be options where we'd lack the authority to actually investigate, where the allegations were previously investigated, and this is a re-report of past abuse or neglect, or where the allegations are patently unfounded. So this would be for an option where we wouldn't have to do very much investigation at all, and we would know that this was 100% not child abuse and neglect. The classic example being we go out on a call about a child having a black eye, and then when we get on the scene, we realize that it's not a black eye, it's leftover makeup from Halloween. So, and those kind of things can happen, and those families should never be in our system. And I think the administrative closure would help everyone to understand that that case never should have been opened and that there was a mistake made. So that was a lot. I don't know if you have any questions for us.
Ms. Frierson, thank you for all you do to protect our children and try to help families, work through these issues. Members, any questions for Ms. Frierson?
Mr. Chair, this is Assemblywoman Monroe Moreno. I have just a few questions, if I may.
Please go ahead, Vice Chair. Thank you.
Thank you. Ms. Frierson, thank you so much for the presentation and bringing this to our attention. I have a question. Have you had an opportunity to speak with other counties or agencies within the state and how they feel about making this change to NRS?
Abigail Frierson for the record. We did mention it in a statewide meeting that involved all the other jurisdictions as well as DCFS. And I believe that they were supportive. I think because of the shortened timeline that we haven't had a chance to go through the exact proposal line by line if there's an agreement with each of these options available, but we did discuss it with other jurisdictions.
Awesome. And I'm sure we'll probably receive a letter from them or comments from them on it. But you had mentioned something during your presentation about a case will be determined unsubstantiated if you cannot determine who the aggressor is. In those cases, is the child left in the home because you can't determine which parent or grandparent or caretaker is the actual aggressor, but there may be signs of abuse?
Abigail Frierson for the record, thank you for that question. If we are unable to meet our substantiation level, our ability to force our interventions on families are limited. Often if that's a situation where we're concerned, but we cannot meet that burden of proof, we'll often offer voluntary services to the family to address whatever issue it is that's occurred and try to engage them on a voluntary basis. So the substantiation is about being able to force the intervention, I think, more than whether or not we will intervene. But if we're not able to substantiate, it would have to be on a voluntary basis.
So, Mr. Chair, my last question. So if we were to make these changes and make the additions to NRS, then that would give you another tool in your toolbox to help those children that fall into that category, correct?
Yes, thank you. For the record, Abigail Frierson. Particularly the unable to complete option, I'm really excited about that being able to open up possibilities for us, because right now we have 45 days to complete our investigation. If we have to unsub it, we can't revisit those allegations. But states that have this unable to complete option are able, if the family ever comes back to our attention, to address those past allegations of abuse or neglect, to vet those to see if they are problematic, rather than just unsubstantiating the case.
Thank you. Thank you, Mr. Chair.
Thank you very much, Madam Vice Chair. Members, any additional questions for Ms. Frierson?
Chair, I just have one additional question.
Please go ahead.
Thank you, Chair, and thank you, Ms. Frierson, for your presentation. So how would be what would be different ways in which you would become notified if that child is back in that community? Would you also be notified from school registration and things like that, or would it just be another report was filed?
Abigail Frierson, thank you for that question. I think primarily through a new report, usually from this, often from the school, but I don't know of another way that we would become aware of a family without law enforcement or a school probably calling it, or concerned parent or citizen family member.
Thank you very much. Any other questions, Assembly Torres? Members, any additional questions? I just had a quick question. If this were to pass into the Nevada Revised Statutes, would these new categories, unable to determine, unable to complete, administrative closure, would they also go into the central registry like an unsubstantiated?
Thank you for that question, Abigail Frierson, for the record. I believe that obviously we probably would have to hash all that out, but I believe that everything would have the same legal weight as an unsubstantiation, except a substantiation, because substantiations do come with legal ramifications. And if we can't meet the burden of proof, I think that wouldn't satisfy due process. So all these other options would just serve to give us more information about what the investigation, but not actually negatively impact those families if we were unable to meet our burden of proof.
Okay, great. Thank you. And under administrative closure, one of the options was patently unfounded. Would that be how would that differ from a unsubstantiation if, let's say, it was the wrong family, or there was some clearly, or the report was just clearly erroneous? How would it be decided whether it would be unsubstantiated or if it would be under the administrative closure, or maybe that's going to be determined later on?
Probably in practice, but I think the main difference between unsubstantiated and patently unfounded is that patently unfounded means we don't have to really do any investigation at all, and we know it's not true. So, for instance, I gave the example of the boy whose black eye wasn't a black eye, or I know we've received a report, or if we receive a report on a 17-year-old who doesn't have someone caring for them, and then she's able to produce paperwork that shows she's been emancipated. So it's the cases that don't require any investigation for us to know they're not true. Another one comes to mind is often toddlers will get a hold of their parents' phones and will call 911 over and over and over again. And then when you get out there, you realize that it wasn't really someone calling for help. It was a toddler with their mom's phone. So those are the kind of cases that would be patently unfounded. The kind of cases that would be unsubstantiated would be the ones where we had to interview everybody. And then as we weighed the evidence, we felt that the allegations were not credible.
Thank you. Thank you very much for explaining that. Really appreciate your presentation, everything you do to protect our kids and help our families. Members, if you don't have any additional questions, Mr. Birch, please go ahead and thank you for being here.
Thank you all. That does conclude our presentation, Chair. So thank you.
Again, thank you to Abigail Frierson and to Tim Birch from Clark County Department of Family Services. Really appreciate all their hard work during these difficult times to protect our kids and help our families deal with some of the issues they're facing. We are now going to move on to agenda item 5, discussion of recommendations for bill draft requests relating to direct file and certification of juveniles as adults. There were submissions from the Office of the Clark County Public Defender and the Progressive Leadership Alliance of Nevada. And I know I sound like a broken record committee, but I do want to remind the committee that as this agenda item relates to recommendations for a bill draft request, one of them at least, made by the Office of the Clark County Public Defender, I would like to advise the committee that I am employed as a deputy public defender with the Clark County Office of the Public Defender in the Juvenile Division. I just wanted to advise the committee of that. And I would like to turn the gavel over to our very able Vice Chair, Assemblywoman Monroe Moreno, to conduct the hearing.
Thank you, Mr. Chair. And with that, we'll move on to item number 5 and have the discussion about the recommendations for bill draft requests related to direct file. And I believe the first presenters will be representatives from the Clark County Public Defender's Office, followed by representatives from the Progressive Leadership Alliance of Nevada. And as soon as you're ready, you can go ahead and get started, and we welcome you to our committee.
Good morning. My name is Kelly Jones. I am with the Office of the Clark County Public Defender's Office, the Juvenile Division. Thank you for listening to me today to discuss the elimination of direct file of juveniles. The direct file of juveniles occurs when the Office of the District Attorney determines, based on a child's age and certain crimes, that they can be transferred from the juvenile court to the adult court system. This is actually under NRS 62B 390. And basically it states, just for a little bit of background, that juveniles at least 14 years of age can be direct filed based on the crime committed, such as murder or attempt murder, and automatically direct filed to the adult court. That is again under the NRS 62B 390. Also, in cases of sexual assault with force or threatened by force, there are some exceptions to this when the child is developmentally or mentally incompetent, or based on the severity of the offense. I did notice that in your last meeting in August that Ms. Bridget Duffy did have an opportunity to speak also about the direct file. One of those concerns was the fact of establishing that the jurisdiction expands of a child over the age of 18. However, in 62B 410, it does allow jurisdiction of the juvenile court until someone is 21 years of age. what we're asking is that we eliminate direct file altogether, that every child receives a certification hearing. That is, a judge has an opportunity to listen to both the defense and the DA's office in determining whether or not a child should be adjudicated either as a juvenile or prosecuted in the adult court. The reason behind this is because we know that children have impulse control issues, that juveniles are not the same as adults, even when you're talking about committing crimes. Looking at the national statistics on juveniles and the way they think through things, again, not the same as adults. By allowing direct file, we're basically saying that children are unable to be rehabilitated. That is not the message that we want to send, I don't think, especially since the juvenile court is supposed to be rehabilitative and not punitive, giving children the opportunity to have services. So in my very brief conclusion, what we're asking is, again, for all children, regardless of their age, regardless of the crime, that they have an opportunity to have a certification hearing in front of a judge. This also allows for what we think would be a better due process for children. You're not allowing someone specifically from the district attorney's office to make that determination of when a child is direct filed. Because once that child is direct filed, it is out of the hands of the juvenile court. So again, we're asking at this point to eliminate direct file. And I apologize, I forgot to mention there are a few states around us that do not have direct file. Utah has just eliminated direct file. Oregon has eliminated direct file. And to go to one of our southern states, Tennessee has no direct file to the adult court. At this time, I would entertain any questions.
Can you read a book? Read a book to grandpa because it's reading. I apologize. I am multitasking in my house, have interim committee and digital classroom. So I'm sorry. I was in the digital classroom for a second there with the kindergartner. Please forgive me. Thank you so much for your presentation. Members, if you have any questions for this presenter, or if you'd like to wait to hear the next presentation and ask all the questions at once, that would be fine. But if there's a member of the committee that has questions for this presenter, you can go ahead.
Vice Chair, it's Assemblywoman Alexis Hansen.
Go ahead.
I have just a clarification question for Ms. Jones. Thank you for being here. When you mentioned the other states that do not have direct file, Utah, Oregon, Tennessee, are those the only states in the union that don't? Do we know how many others don't?
Again, for the record, Kelly Jones from the Clark County Public Defender's Office. I apologize, Assemblywoman Hansen. I don't have further information. I happen to work with some of the representatives from that state. So that is why those states, which is why I'm aware of those. I do need to do further investigation and research on other states that have eliminated direct file. And I can get that information for you.
Thank you very much. I would appreciate that.
Ms. Jones, I have a question. As far as direct file goes, does the DA's office use it as a negotiation tool where, like with a plea agreement, how does it actually work for the direct file?
Thank you for the question. Again, Kelly Jones for the record. No, once a child has been direct filed, again, jurisdiction is lost by the juvenile system and it goes directly to the adult court. In certification for certification cases, yes, they do use it as a negotiation tool. But it never gets to that point. for direct files.
And I know we've heard in this committee, in the last two interims, a number of conversations about direct file. We've had issues with the placement of youth that kind of fall in between the adult system and the child welfare system, and there's nowhere to put those children. And then, have you thought about that? And then you spoke about that our system should be more of a rehabilitation, because these individuals are still children. What rehabilitation programs have you thought of? If we do get rid of direct file, what do you foresee as the programs and how the impact would be on the counties throughout the state, the housing of these youth offenders?
Again, thank you very much for the question. Assemblywoman Monroe Moreno. As far as the housing is concerned, we have thought a little bit about that as far as them remaining in the juvenile system, if that is necessary. Again, we would have to go through and see what the actual services would need to be. Currently, I know we are in the midst of using a new system in determining individual plans and services for youth. I would think that that would still occur even if we got rid of direct file. As far as those services are concerned, one of the things, again, that was mentioned by Ms. Duffy, and I think needs to have even more of a spotlight, is looking at the mental health services for our juveniles. What we're finding more and more as we are consulting and advising our clients, we're finding more and more of them do have mental health issues. I think that is going to help. Additional services, we would be looking, increasing the services of such as the Boys and Girls Club, giving children an opportunity to have outside or things to do outside of just school or just sports in school. So those are the type of services we would be looking. Also, additional counseling for children, again, going towards their mental health issues.
Thank you for that. So what I hear you saying, and correct me if I'm wrong, is that if we were to eliminate direct file, each child that entered the juvenile justice system that would have been considered for direct file would now have their certification hearing. And by doing that, each case would be treated on an individual basis and go towards the specific needs of that child. Is that correct?
Yes, that's correct.
Hey, members, do you have any other questions before we move on to the second part of this presentation?
I do.
Good morning, Senator Hammond. Go ahead.
Thank you. So just so I understand and I'm clear, if the child then is determined to be, let's say, incompetent or violent, it'd be up to the court then to decide whether they go, they're adjudicated as an adult or not. Am I correct in saying that?
Yes, again, Senator Hammond, and again, Kelly Jones for the record, that would be correct. All juveniles would have an opportunity to have a certification hearing to determine whether they should stay within the juvenile justice system or if there's truly a need to move on to the adult system.
And right now, I know that we banned this. I think we banned this when they turned, I think, 14 and younger, we banned it. So this would go up to 18 and younger, or is it higher than that? Is it 21? I mean, I guess what I'm getting at is how many more, we're going to have to increase the number of cases then that have to be reviewed instead of going directly. And so how does that play out in the courts? Is that how many more times or how many more people are going to see in front of the juvenile courts?
Again, I did notice from the last notes or the last minutes of the last hearing, and Ms. Duffy did mention that we would have to actually get that information about how many cases we have that are actually direct filed. and also break that down by age, background, and ethnicity. So I don't have an exact number for you at this time, Senator Hammond.
Thank you. That's fine. I get called all kinds of stuff. So one last question for you, and that is, you mentioned a minute ago, you thought that the tactic itself right now is kind of being used as a tool, as a negotiation tool. How does your department then handle that negotiation tool? What's the give and take there? I mean, if you guys, if they come back at you and use it as a tool, but how do you handle that to try and make sure that this, making sure that some of the youth are not put in direct file, or I guess how do you handle that?
And I apologize, Senator Hammond. I don't think I was being very clear. For direct files, there is no negotiation. Once the DA has decided to direct file a juvenile from the juvenile court system, they automatically go to the adult court system. So there is no negotiation there. However, with the certification, I apologize. It was probably me. With the certification hearings, there tends to be negotiations. So from the standpoint of, we try to make sure that the certification hearing will occur based on the crime and based on the negotiations that were given by the DA's office. Again, like our normal cases, after reviewing all the evidence, we determine whether or not that's going to be the best for the child. And usually when they're using the certification hearing as a negotiation, it is actually to place them in a juvenile facility rather than going through the actual certification hearing. I'm hoping that kind of answers your question.
Oh, I do. Thank you very much for your answers. That's all I have.
Perfect. Members, any other questions?
Yes, I have a question, Chair, Vice Chair.
Go ahead, Assemblywoman Torres.
Thank you, Vice Chair. And thank you so much for your presentation. I really appreciate all the work that you do for our kids in our juvenile detention centers here in Clark County. And I just wanted to ask some questions. So once a juvenile has been direct filed, do they receive any additional juvenile services once they've been moved to the detention center? So if they're receiving like youth mental health care, schooling, like what types of services are available for juveniles that have been transferred?
Good morning, Assemblywoman Torres, and thank you for the question. Again, Kelly Jones for the record. My understanding is once they are transferred to the Clark County Detention Center, they are placed in a separate area as far as housing is concerned, but I'm not aware of them receiving any other services as far as education or mental health services. That does not happen until they actually move within the adult system.
Thank you. That's particularly concerning for me just because I believe all children deserve an education regardless of what they may have done. So I think that that's definitely something that needs to be resolved, and we need to figure out how to ensure that we're able to provide a kid that education while they're in the middle of like this limbo process. So that's particularly concerning to me. And I just wanted to understand, so if the juveniles are able to stay until the juveniles, that recertification hearing would be like the time for them for the judge to really look at and evaluate those options to determine whether or not that particular individual, that particular juvenile would be better fitted for a different type of court system, correct?
Again, Kelly Jones for the record, and yes, that's correct. It would give the judge an opportunity to review any extenuating circumstances, the background, the history of the child. It gives a full picture of that child at that certification hearing. Thus, I really feel that it gives us an opportunity to have a better due process system by having all of our children go through this certification process rather than having the direct file.
Thank you. And so if at that time, sorry, one last follow up, but if at that time the judge determined that juvenile needed like additional mental health services and things like that, that child then wouldn't have to go through that judge could have the discretion to allow for that juvenile to receive juvenile services instead of just moving to the adult facility where they'll still be in a separate, but they're not going to receive the juvenile services that we know that the juvenile system can provide.
That is correct. That's absolutely correct.
Vice Chair?
Woman Hanson, go ahead.
Thank you. I'm sorry, I want to make sure I'm understanding correctly. A juvenile that receives no services, if they're treated as an adult, wouldn't get any of the kind of services they had if they were treated as a juvenile still, or in a juvenile facility?
And good morning again, Assemblywoman Hanson. Kelly Jones again for the record. It is not that they don't receive the services, they won't get them immediately. They would have to go through the adult process. So they would have to go through their preliminary hearing. They would have to either go to trial or they would accept a plea agreement. That would then have to go to the judge who would determine whether or not they would actually go on probation or if they would actually go directly to prison. And so those services would only be determined during the sentencing phase of the adult side of the court. So it wouldn't happen while they were in the Clark County Detention Center.
If I could follow up. So how long, just ballpark, how long is that process if we're going to refer to it as limbo perhaps?
Depending on the crime, Assemblywoman Hanson, it could be anywhere from 3 to 9 months.
So 3 to 9 months. I'm sorry.
Yes, I had a current
no
client.
juvenile services.
I'm sorry.
I'm sorry for interrupting. This technology causes us to interrupt, so I apologize. So if it were a 3 to 9 month period, which we'll refer to as limbo, for lack of me being able to find another word, if there's an actual legal word, those juveniles are receiving no educational services or other services that at that point.
No, ma'am. Not at that point. At least from the previous client that I had that I spoke with.
Thank you very much.
Senator Hammond, did you have a question?
Just a follow-up, because the 3 to 9 months was kind of disconcerting. Is that an average, or is that something that you're experiencing right now with this particular client? I think you're referring to a client, or at least I thought you were. Is this on average that you're only getting 3 to 9? It takes 3 to 9 months for that person to start getting any kind of services, especially education, or is that maybe an extreme case? Is 3 months normal?
I would probably say the average would be 6 months. And I'm sorry, again, Kelly Jones for the record. And that's to have their case processed through the adult system. And again, that depends on the crime that was committed and where they stand in that legal process.
Okay. Because I
So
thought
that is
CCSD, yeah, I thought CCSD did have something there at the detention center, though.
Again, speaking to my former client, he did not give me that information.
Okay.
Vice Chair Monroe Marino.
Go ahead, Miss Hanson.
That's okay.
Sorry.
I've been called a lot of things too, like my colleague Senator Hammond. Do we have anybody that can give us some insight about this? Your client is saying this, but it's juvenile. I thought I had heard that juvenile services, these detention centers do provide some sort of services during this period. Do we have anybody on the line that could let us know? Was this client an unfortunate, was the exception and not the rule?
It appears that the person who's going to be speaking after me does have some information, because I did see something in the chat that they can help. Holly Wellburn said that she could help.
Thank you.
All right. Well, Ms. Jones, thank you so much for the presentation. And with that, we will move on to the second part of our presentation and get some of those questions that were asked to you answered during the next part of the presentation. So the next in queue, you can go ahead and get started.
I think that would be me. This is Leslie with Plan, and I'm actually going to pass it to Jageda because he's actually giving the presentation.
Thank you, Mr.
Greetings. My name is Jageda Chambers. I'm actually a fellow with the Mass Liberation Project under the Plan umbrella, Progressive Leadership Alliance in Nevada. I want to thank you, Honorable. Go ahead. I'm sorry. Thank you, Ms. Chair Moreno. I had notes, but I kind of want to just dig in. First and foremost, we're talking about Black and brown kids specifically. I want that to be very, very clear. Black youth as a population in Clark County School District or Clark County have never got over that 10.5, 11%. But they continually make up the bulk of direct files. I really want to highlight that I feel that this is the foundation for the school to prison pipeline. The ramifications that come in no longer looking at a child as a child and saying by a decision or a bad choice that they make, they are now to be viewed as an adult. The ramifications throughout the juvenile criminal justice system, I don't even think they could be measured. One thing, I definitely feel it is a tool in a pretrial state to support Ms. Monroe. There is a level where the threat of it is always in play, okay? The threat of it is always in play. And I don't feel like we're talking about a lengthy amount of violent crimes where these youth are being transferred to the adult court. Again, our arguments are going to be specific around the Constitution. The Constitution has dictated the age of when a juvenile should be viewed as an adult. I know that there are other jurisdictions in our country where you're not even viewed as an adult until 19, 20, 21. So just that parameter to no longer view a child as a child from a decision that they make, I think that is something that has to be pulled out. The racial and ethnic disparities when we're looking at direct files, to me, that's where the medicine is going to lie. If we really want to get to really getting beyond where we are, not only in Clark County, but as a country, I really think this is the founding piece of how we're treating our Black and brown kids, not only in this county, but in this country. There are over 250,000 youth that are sent to adult court a year, okay? There are over 250,000 that this happens to. My direct involvement and passion came from the 2017 stats. There were 41 direct files, 27 of them were Black and the other 14 were Latino. There wasn't a white youth that was sitting to adult court. Needless to say, those racial and ethnic disparities were alarming, and it piqued me. I didn't have a clue that Clark County's Black youth population never gets over that 10, 11% plateau. Again, the school to prison pipeline is such a hot topic, not only here, but around the country. Again, I petition this honorable committee to try to look into this direct file piece, this minor component this minor few sentences in the Nevada revised statute being a pillar into what we're doing with our youth. We know that there has not been 140 youth murders or 140 something youth violent crimes. So we really want to know who is getting direct filed and why. I know Mrs. Duffy was able to represent the Juvenile District Attorney's Office and present to this honorable committee. And I think their office would know a lot more, but a lot of the data is not there. We were able to spend some time with that office in September of 2018. And to be brutally honest, the things that we thought were important, what was the arresting agency? Did he have an adult co-defendant? Was there an IEP in place? Just common steps that you think would go along prior to sending a youth to adult court. None of those have been taken into consideration. That's why I feel like for this honorable committee, we are almost beyond a study or a review. This has been 3 decades plus of people that are Black and brown that have been impacted by this. What is most alarming to me personally is that from a period of dating back to from 2013 to 2017, there were over 140 youth directly filed into the adult court system. Okay, 147 to be exact. Not one of them was a female, not one. Out of that 140, out of the 147, 140 of them were youth of color, 96 being Black. Okay, so these are Black kids that are making 10% of the population, but over the last 5-6 years are making up 65% of the youth that are being transferred into the adult court. So it's a bear trap and it's a noose that's only hanging Black and brown kids. And here in Clark County, we had an alarming scenario at Arborview High School where there was a terroristic threats, where there were some lives of Black youth that were threatened. The threat had applicable credibility because one of the parents of that was charged with that crime, his father had over 100 weapons in the home, but these youth weren't direct filed into the adult court system. So again, I want to do away with it. I'm not trying to say, hey, let's start direct filing white youth. That's not what Jugate is saying. I want to do away with the practice that we know is only capturing our Black and brown brothers and sisters. Again, prior offenses, what is going on? One thing that was discussed to Senator Hammond, I know there was a juvenile who committed a crime in September of 2017. He's in custody now. The COVID crisis was such an alarming situation for his mama. She came up with nearly $500,000 to get her baby out of custody, okay? It is, when the youth are transferred to adult court, please, we have to stop viewing them as kids. Once we send them to adult court, they're viewed as adult. They're on the program of adults. The 23-hour lockdown that have hit the Clark County Detention Center for the COVID crisis, a lot of that had hit the youth that were in custody. So there are a laundry list of scares or alarms that go along with a youth being transferred into the adult court system. Also, the reality of what we could do if we weren't sending these 25 to 40 Black and brown youth to adult court. What could we do? I think it starts with culturally rooted healing. We're talking about a specific set of kids that need a specific set of energy. I think that has to be highlighted. This isn't a plague that is affecting the entire youth population for Clark County. And I would be amiss to not mention that. Please don't think that of the 150, 160 plus direct files that have happened since 2013 in Clark County, don't think those are all murders. Don't think those are all violent crimes. A lot of those are youth who have been sent on probation because of possession of pot or for truancy. And now you're in a vehicle with an 18-year-old adult and you get caught with a pistol. A lot of things will usher you into that adult court status. So again, no one knows better than those 25, 30 years of kids who have been thrust into the adult court system. And a lot of those youth have made their way back home. So if there were any effort to study or get involved, tap in with those youth that have been sent to adult court 15, 20 years ago. But again, that's going to be such a challenge because minimal records have been kept on these babies that we send to adult court. I really want to highlight mental health components, what we would do with these youth. We're in talks with an organization, a phenomenal organization called Youth First. And what they have done in New Jersey is actually got, i.e. A department store, a vacant shopping center, and have built that up to house your youth, to keep them right there. You know, allow some of the medicine that happens from our community to get direct access to our youth in custody. So there are different jurisdictions that are taking this step. I think it boils down to looking at our kids as kids. There's nothing that a youth can do that is preserved for an adult except be charged into adult court. He can't smoke a cigarette, he can't grab a vape, he can't vote, he can't sign up. There's so many restrictions that we would never think to look beyond them. But for certain scenarios, again, these are not, don't think that we're talking about 40 murders, youth murders a year. These are certain scenarios and circumstances that are reserved, again, for Black and Brown youth. So if this honorable committee was able to take any effort or initiative into eliminating this practice and just taking care of it through the statute, needless to say, it would be so rewarding and impactful to our community, again, because there is no youth that is unrepairable. What we do with our Black and brown youth is we don't see them as repairable. You see the 14-year-old as you see his uncle and his daddy in prison, and we see that as their logical route. But again, I'm a school to prison pipeline guy. I got suspended multiple years, ended up getting expelled. And, you know, I had to figure it out in the penitentiary. But I don't think that is the medicine, especially for our youth. When we're talking about 23-hour lockdown, that's irreparable damage. And what it does is creates the foundation where Clark County School District Police is going to come in and arrest and handcuff an 11-year-old baby girl. And she's going to be left in custody for 4 days. And she's going to be charged with a felony for grabbing a pair of safety scissors, okay? That's the climate that comes in place when we do direct file our children. Once we surrender looking at any child as a child, and that's how you get 11-year-olds handcuffed on campus in front of their classmates. That's how you get 11-year-olds left in custody for 4 days. That's irreparable trauma. So I think this is a step to healing not only just youth that are transferred into adult court, but how we view all of our babies that need more attention, that need a little bit of help. I'll surrender right there. I know myself and Leslie Turner are definitely available for questions, and I'd be sad if I didn't get one too. So thank you.
Thank you so much, Mr. Chambers, for your very passionate presentation. I feel your pain. Are there any members that have a question for Mr. Chambers? I am going to ask the ACLU. I know that they're on the line for one of our other agenda items, but I know that they have some numbers specific to questions that Assemblywoman Hanson had. So does anyone have any questions for Mr. Chambers before I move on to Ms. Walborn?
Good morning. Thank you.
I'm sorry, Ms. Wellborn. It's Assemblywoman Hanson. I just wanted to I didn't have a question. I just wanted to thank our last presenter that I don't have a question because you were very thorough. So I appreciate the information, appreciate your passion. And we care about all children and, you know, the Black and brown children, all children. And that's why we're here on this committee, and we want to vet these things and get some good solutions and answers to these things that concern us all. So thank you so much for your dedication to trying to, help the lives of these children that are, caught in a system that concerns us all. Thank you.
Thank you. Ms. Walburn, if you want to go ahead and get started.
Thank you. Holly Wellborn, Policy Director for the ACLU of Nevada, for the record. Thank you, Vice Chair Monroe Moreno. I just wanted to provide a little bit of clarification on the education issue. We will talk a little bit more about our study that we facilitated back in the last interim before the 2019 session, where we went and we did a facility assessment of all local institutions, the Lovelock Correctional Center and their youth pod, the Clark County Detention Center and their youth pod. I also want to thank our presenters. We really are in this fight together to find the best solution for young people. And I think, our presentation coming up will provide clarity on how all of this works together. But what it is when it comes to providing adequate services, at least what we found, and we certainly want to hear if there are young people who are getting lost in the cracks, because, between some kind of procedural outcome. But in our facility tours, the Clark County Detention Center does have educational opportunities available. Actually, in our assessment, we did find that it was quite a good educational system. There's a lot of hands-on training for young people in the Clark County Detention Center Youth Pod, but that doesn't mean that these institutions and these adult facilities are able to meet all of the other variety of needs that young people have. So, for example, we know that the nutritional content of food available at CCDC has come under scrutiny. It's been found to not be, nutritionally adequate for a young person. There's also no outdoor yard opportunity. They do have one of those indoor yards that has the open chain link fencing above them, but no real adequate opportunity from our perspective for real large muscle exercise that young people need. I mean, there's a basketball court, things like that, but in order to, be out in the air, have time, for that type of recreation, that's found to be uncontroversial in the need for young people to have that type of physical interaction with other people. So we'll dive a little bit more into it. And I don't know if I'm permitted to put our study into this box, just so everybody kind of has it in front of them. Am I permitted to do that?
So that would be a question for our policy analysts. I don't see a reason why there wouldn't be, because it's dealing with the subject matter at hand, but I will ask Mr. Guyon.
Thanks, Madam Chair. Patrick Guyon for the record. I would just ask Holly if that is going to be a link that's part of your presentation under the next agenda item, that maybe we just move it to the next agenda item and look at it then, rather than confuse this agenda item.
That sounds great. But I do want to, clarify for the record and be responsive to the question that there, most facilities have contracts with their local school districts. And if there's a delay in getting to those educational opportunities, that's something we certainly want to know about and see if we can fix it. But my understanding is that most kids are sent to CCDC after certification, pre-trial, and they do get educational instruction.
Thank you. Are there any members that have any questions for Ms. Walburn on this agenda item? And Ms. Walburn, I'm going to ask you to stay. Don't go anywhere. Okay. See no questions, then I am going to move on to the next agenda item on our agendas. It's agenda item number 6. And Ms. Walburn, since you were one of the presenters on that next agenda item, since you are already on screen, I'm going to go ahead and ask you to start out that agenda item. It will be the discussion of proposals for appropriate state and local entities to develop a memorandum of understanding to house youthful offenders in juvenile facilities. And so with that, Ms. Walburn, if you will kick it off, and then we will go into our next presenter after you.
Thank you, Vice Chair Monroe Moreno. Again, Holly Wellborn, Policy Director for the ACLU of Nevada. I went ahead and linked a report. I've submitted this to this committee quite a few times over the last few years, but this was published in the summer of 2018, preceding the 2019 legislative session. We have been advocating to both end, direct file of youth, as we've heard in this other presentation. We think that's one of the best solutions for resolving the issues that we have with youth detention in Nevada, but also trying to find solutions for young people who are currently serving out a term, either awaiting pretrial in an adult institution at the local level, and for the young people who are sent into the Nevada Department of Corrections. So I think that all of us were quite shocked to learn this past legislative session in your past meeting that 4 young women who had been sent to the adult system were transferred out of state. I was not aware of that after going through this process. It was a surprise to me to learn about that. I had asked a few questions. It's my understanding that the young women, they are in a state institution, and I don't know that there's any current plans to remove those young women back to Nevada. So I bring up a report, and I think it's important to remind the committee, what our conclusions were. And what we did was a minimum standards assessment, not a best practices standards. Every facility can do exponentially better, right? But of course, we're living in a state, especially now, where we're fighting for money, right? So it's really the question of what do we need to do to have the best outcome for kids given all of these circumstances. What we concluded, and what I think most administrators will admit, and I know that the Nevada Department of Corrections will admit, we very much see this as a partnership with the Nevada Department of Corrections on finding a solution for young people, particularly the young women who have been sent out of state and the boys who are living in Lovelock Correctional. We've concluded that adult institutions are not equipped to handle the unique needs of young people. Most youth living in the NDOC will be released to society within 6 to 10 years. And those that do have life with parole, we know that under United States Supreme Court precedent and under Nevada statutes, that most of those life without parolers will one day be given a meaningful opportunity for parole and will likely be released. The strict adherence to sight and sound separation requirements in the Prison Rape Elimination Act and under JJDPA have created barriers for being able to provide the high level of intervention, education, jobs, et cetera, for young people in order to be successful if they are on a track to one day no longer be incarcerated. We know that the solutions for young women are very minimal. So I want to explain what's happened with this situation with young women. One of the proposals back when James Arenda was the director of the Department of Corrections was, perhaps what they would have to do is build a portable unit. And at that time, it was one young woman who had been transferred, and to have that young woman housed in that portable until she reached the age of majority. This, by our standards, is solitary confinement or administrative segregation, as the department would call it, which is completely unacceptable for a person under the age of 18, for any individual, particularly for children, because we know of the harm caused. We are in this conundrum where we don't want to place young women in solitary, but we also don't want young women to go out of state. It also presents serious sex discrimination issues where boys are treated one way, girls are treated another way. It takes them out of the state and away from their families. There's been litigation throughout the country that has sought to move girls who have been moved out of state in other jurisdictions. Most of those cases, there's nothing that's been decided on the merits. Most of those cases had been dismissed because those girls had reached the age of majority before it got, before the case was heard or went to trial. But we know that that's lingering there. So I say this, and I really want to drive home the point that we need to find solutions. We've embarked on this road through this study. We've worked in collaboration with the DOC, with our juvenile institutions, So what is the answer? And I think we have a few conclusions for you. One of those answers is to look to our states. There are currently 11 states that house youth who are transferred out or either certified through that process that you heard about prior, who stay in the juvenile institutions. And there are zero problems. In fact, it's drastically reduced the recidivism rate among youth and has been shown to have the best possible outcomes for young people. And there's a variety of ways to get there. And then, of course, you've heard about direct file. And ending, direct file and really taking a look at each individualized youth, that is going to enable the possibility to retain those youth in the juvenile system, because we know that youth are simply different than adults when it comes to the way and the reasons why they enter the criminal justice system. So I'm going to stop talking, and I would like to introduce Marcy Mistrett. She is the CEO of the Campaign for Youth Justice, and she can talk a little bit more about a state-by-state analysis on this issue. Go ahead, Marcy.
Thank you, Holly, and thank you to the members of the committee for introducing me or allowing me to speak today. I really appreciate it. As Holly just mentioned, I am the CEO of the Campaign for Youth Justice. We are a national organization that was created 15 years ago to raise awareness and solutions for young people who are prosecuted, sentenced, and incarcerated as if they were adults. And so I have worked on this issue for many years, both at the state and federal level, to try to help educate folks on what actually does work when young people are charged as adults. And I do want to thank, I'm going to try not to be redundant over our last several speakers who have done a great job laying out some of these issues. So forgive me, it is very hard for me to talk about just the removal of children from adult jails and prisons, from adult facilities, without also talking about how they got there in the first place, right? So I will do my best to try to keep those discussions separate, although I will say that excluding children based on their age and charge, what everyone's referring to as direct file in Nevada, is a huge reason that we have so many children that are in adult facilities to begin with. So they are inextricably linked. One thing, and I'm going to start this with just a little bit of historical context. Before, in the 1990s, before we kind of had the era of treating children like adults, era of super predators, there was only 7 states in the entire country that skipped that very, very important step of a judicial transfer hearing. Only 7. Now that number is up to 34, right? So we skipped that step in most of our states. And it's not that those certification or those waiver hearings went away. It's just that we grouped a bunch of children based solely on their age and the crimes they were charged with as being automatically excluded from those jurisdictions, from juvenile court jurisdiction, right? So those statutes around, a waiver hearing, a certification hearing, where children have representation, where there is more than just a police report, where DAs actually had more than, 24 to 72 hours to make their charging decisions. That does exist in 45 states. That possibility to do it that way does exist in 45 states, including in Nevada, except for that we have carved out this group of children who don't get that opportunity. They start immediately in the adult court. They're no longer considered children. And so we are at the point now, 15 years later, where we have made as a country, based on research, based on Supreme Court jurisprudence, based on what we know now about adolescent brain development and neurology, we've started to change this as a country. We've started going back to look at our practices. And to Mr. Chambers' point earlier, I just want to reiterate, our children are not the ones driving violent crime in our communities. As a matter of fact, nationally, we are at the lowest point of juvenile crime that we have been in 50 years. We have reduced nationally, we've reduced youth incarceration by more than 60%, and we've reduced the number of kids charged as adults by more than 70%. So while we have moved all of these children back to the juvenile court, which is the appropriate place for them to be, we have also dropped our youth crime, right? So those two things if we treat children like children, they are much less likely to engage in more criminal behavior. They are not linked. There are 22 states that have restricted the placement of children in adult jails and prisons. And we also have 2 federal laws that Holly referred to that I'm sure this committee is well aware of, but both the Prison Rape Elimination Act and just recently in 2018 and signed by President Trump, the reauthorization of the Juvenile Justice and Delinquency Prevention Act, which since 1974 has required states to keep children, delinquent children or children with status offenses out of adult jails. What the new reauthorization did is to say that should be tied to any child who's under the age of majority, including children who are pending adult charges. So states basically have till the end of next year to deal with that, or they'll start to get federal penalties. So does that make sense? Everybody with me so far? Yes. Okay. There are 24 states right now that allow young people, and Nevada is one of these states, right? There is a period of time where young people, even those charged as adults, can be housed in youth facilities. There's only 8 states, and this is before the law passed, but there's only 8 states that presume and really have no way at all for any child to be held in a juvenile facility. So even before this law passed, there was at least wiggle room for states to make that decision on a case-by-case basis. Well, over the past 2 years, we've seen rapid movement around this, and 9 states in the past 2 years have changed their laws prohibiting children pre-trial to be in adult facilities. Most states have already changed their law post-commitment, so any child that gets sentenced to adult time because of PREA, because of the high costs of PREA, because as Mr. Chambers referenced earlier, there actually isn't a lot of kids who are under 18 by the time they're sentenced and going to adult facilities. So it's a huge burden on facilities to take care of them in the way that federal law and best practice requires. And so, you know, we have moved the field tremendously once they understand that they actually have decision-making authority about where these children belong. Most places, when they look at this, realize that the juvenile system is the appropriate place for all of these children, particularly pre-trial when they have not been convicted of any crime. So in the 1990s, the number of children who were under the age of 18 that slept every single night in adult jails and prisons was close to 13,000. Last year, that number dropped to 3,000. So we are making progress, right? And I think that the way that people have done this, and I've seen this in Nevada as well, right? We have looked at our juvenile justice system, and again, to Mr. Chambers' point, the way we're handing school to prison pipeline. We started realizing like, oh God, we're locking up these kids for skipping school, and then they're actually 14 times less likely to ever go back to school again, right? So maybe we should look at this a different way if we're talking about solutions. So our juvenile justice system has begun to shrink. And in my opinion, that then provides us with the opportunity to bring these children who are just automatically excluded from any sort of consideration from juvenile court back to the juvenile justice system, where they can get a fair and comprehensive review by a judge with an attorney present. Again, as Mr. Chambers said, I think the assumption is we all go to the worst crime, the front page story. That is not the bulk of children who end up in the adult court. And as a matter of fact, a lot of the best practices that we have seen that work to reduce recidivism, to get kids on the right track, that are developmentally appropriate, are interventions that were designed with children with very serious or chronic or violent charges in mind. So things like MS, multi-systemic therapy, family functional therapy, a lot of the cultural healing practices that are out there were all, even things, why am I forgetting the name of I'm sorry, I'm blanking on the name of the program. But even housing programs, voc tech programs have taken children with very similar histories as the children that we have excluded and have been incredibly successful. They were who the children were designed for. And the doctor that created MST will talk at length about the fact that the children who are now being served by not being served, but in the adult system are the children that his program that was designed to attend to. It is a family system model. It is understanding that children don't live independently yet, that they live in a family setting. And it is why it's gotten so many very, very positive outcomes. I did want to touch on the question, Holly's talked about the number of states that keep children already. 70% of children in the entire country who are charged as adults are already held in juvenile facilities. So again, most of the states have already done this or are moving rapidly to doing this. But the other piece I want to talk to, and I think Mr. Chambers talked about this, there are actually 16 states in the country who require a judicial waiver hearing or that juvenile certification hearing before that child can move to the adult court. Those states include California, Connecticut, Hawaii, Kansas, Kentucky, Maine, Missouri, New Hampshire, New Jersey, North Carolina, North Dakota, Ohio, Rhode Island, Tennessee, and Texas. So in all of those states, a child absolutely has to get a hearing before they are able to be certified by a juvenile court judge who's much more likely to be trained and to understand the services that would be available to that child should they remain in the juvenile justice system. I'm going to share real quick a screen to show where the movement has been very recently. And I know I'm throwing a lot of information at you, I'm sorry. But here we go, right? If you look here, can you guys see my pointer? Or no? Yes? Okay. So you see in these first two columns, these are judicial waivers, right? There's actually 3, but none of the states had the third one. So either a judge has full discretion over the certification, or there is a presumption of waiver for certain children based on their crime, or the third one would be mandatory waiver. So a judge is basically just verifying that the charge and the age of the child is verified, and then they transfer the kid up, but they're still in a juvenile court by a juvenile judge, right? So that's the first 2 columns. The second 3 these are all children who have no touch at all with the juvenile justice system. They start in the adult system. We call that, and it's all 3 branches of government. So the way we break it down is statutory exclusion. So the legislature has determined under statute the age and the charges that have to originate in adult criminal court. You guys are referring to that today as direct file, and many states do. So that is the legislative branch, right? Then you have, these are the judicial branch, and then prosecutor discretion is considered the executive branch because it gives the full authority of determining which children start in juvenile or adult court. The prosecutor has full discretion on which child goes where. There's only about 13 states that allow that. And then this once an adult provision means if you have, depending on the state, either if you have an adult charge or an adult conviction before you reach the age of majority, any subsequent charge will also land you in the adult system. So if you get you get excluded because you have an armed robbery, you plead to something lesser. You plead a simple robbery, but it's still an adult conviction. And then you get another charge, a misdemeanor theft, right? That misdemeanor theft is also an adult charge, okay? And then these are more about sentencing and ways to mitigate those harm. And then the last column here is which of these states house children under the age of majority in adult jails and prisons. So you'll see California, 16, no one under the age of under 16 in California can be waived no matter what they do, right? And a judge has to have a full certification hearing. They used to have prosecutorial discretion, but in 2016 they ended that. and children under the age of 18 and and up to age 24 are mandated to remain in the youth justice system, even if they have those adult charges and sentences. And I'm going to pause for a second on California. I know California does not represent the rest of the country, but I am just going to say this. They went from 1,100 kids a year in the adult system to 44 last year. From 1,100 to 44, their crime rate overall has not gone up, and these kids are staying out of the adult system because they're getting the age-appropriate services and interventions they need before becoming adults. Colorado still has a pretty low minimum age. They, again, changed the number of kids in the adult system. They totally restricted. No one under age 16 can be considered without a hearing. And it was a very limited number of charges. And they've dropped that down to under 10 kids a year now, automatically starting in the adult system when it used to be over 100. Here's you guys, so you can see where you sit in that. Oregon got rid of their Measure 11 last year, totally got rid of it. Now every child 15 or older, a judge can review it for a certain number of charges, but they got rid of their automatic transfer. Utah, again, just this year, greatly reduced it. It is only for murder and aggravated sexual assault that children 16 or older can even be considered in the adult system. And again, Washington State also dramatically narrowed the charges that are eligible. And if you see here, all of the states around you guys have already gotten the kids out of their adult system. So pre and post trial, these children are being housed in age appropriate facilities with trained officers in adolescent development, with mental health providers that are trained in adolescent development. They have contact visits with their families. They get free phone visits with their families. They get all of the IDEA and education requirements up to age 21. We designed separate facilities for kids because we recognized they had unique needs. So even though Nevada is doing a good job about getting education in their adult facility, it doesn't mean that those kids have access to their families, to outdoor recreation, to appropriate nutrition. And when those facilities go on lockdown for COVID, for other emergencies, those kids are locked down 23/1, just like anyone else in those facilities. So I think I'll take a pause and then answer your questions because I know I just threw a lot at you. But I think there's a real opportunity here for Nevada to continue on the work that you've actually already started. And I think it just it's common sense. And we just have to realize that, 90%, 95% of these kids will be home by the time they're 24. That is when we see the desistance curve drop, right? So kids stop engaging in delinquent behavior at around 24 years old, right? When they age out of adolescence. And then the last thing I will say, I know I just said I'm going to finish, but I want to underscore what Mr. Chambers said. The racial and ethnic disparities of children who are not preserved their right to a childhood by the criminal justice system is alarming. It is the most disparate point on the entire entry points on the entire continuum of care for juvenile justice. Nationally, we are talking about 88% of children sentenced as adults are Black and brown. 88%. Yet when you look at their self-report data of how they engage, what they are self-reporting their behavior to be, you see very little difference by race or ethnicity in their behaviors. This is about how we view these children, how we invest in support their families during crisis of time, and we have solutions on how to get better about serving all of our children. And as Mr. Chambers said, that healing and cultural practice is a big piece of those successful programs. So with that, I open it to questions.
Well, I thank you so much for your presentation. And I would ask if you could send this screen to our committee policy analysts so it can become part of our meeting materials. That would be extremely helpful. And then listening to the conversation during this meeting and our last meeting, yeah, I kind of, my career was in correctional law enforcement. While I worked with adult offenders, I often worked with adult offenders that had just recently left the juvenile justice system. And I think I just have to put it on the record. Our DAs, for the large majority of those that I interacted with that work in the juvenile justice system, are people who truly care about our children, and they're working within the confinements of the statutes that they're given. But they truly care about our kids. And I just want to make sure that that's out there so that they're not painted in a negative light today as we have this discussion, because they're not part of the discussion today. They may come up during public comment, I don't know, but I just want to put it out there. We have people that are working with our children as public defenders in the DA's office, in the public defender's office, that truly care about the children that they come in contact with. And yes, there are some improvements that we do need to make to our system so that it better treats on an individualized basis all of our children, no matter what race or creed that they are, but is a better system in addressing the needs of all of our children. And it does sadden me as an African-American woman that the number of children that we see being filed are children of color, and how we can combat that. So I just wanted to put that on the record. Members, do you have any questions for either of these presenters?
I do, but I'll wait in case anybody else has one.
And Ms. Wellborn, I'd also ask if you could speak directly to the Memorandum of Understanding and what that would say. And
Sure, and Ms. Mistrett could probably offer a little bit more clarity on some of those contracts, but we know that in both Washington and Oregon and a few other states, the main primary point of, how do we facilitate moving young people into the, retaining them in the juvenile justice system. When we had these conversations, there is, a cost associated, which is why, we decided to run with this study and see what the possibilities are. But the way that it's worked out in some states is the Department of Corrections enters into a memorandum of understanding with the juvenile institution, and also takes some of that funding, the funding that would be used to retain the kids in DOC, would be transferred over to the juvenile system. There's also in some states an arrangement where and I believe Ms. Mistrett spoke to this, but there is an arrangement where some correctional facility staff are on hand at the juvenile institution to handle, any kind of therapeutic interventions that might need to be DOC approved for whatever reason. So that is one, possible solution that could move forward regulatorily. I think, some states have authorized that, and it's been quite successful in making sure that youth get, the full spectrum of care that they need. Did you want to add something to that, Ms. Mistrett?
I would suppose the only other thing I would add to that is, as our, again, nationally, you guys, I'm actually not exactly sure of Nevada's numbers right now, but I know you've made so many adjustments along the way, that there's kind of some static costs with running a facility. And again, and so as our juvenile population numbers go down in juvenile detention, we have space for children that isn't actually going to cost a lot more than serving the children that are there. So we have seen that run that way. And then we've got policy platform statements from the National Sheriff's Association, from the Major Cities Chiefs of Police, from the Correctional Juvenile Justice Association, all calling for jail removal, because in general, you have very few children in these adult facilities. And as Holly mentioned earlier, both between PREA and JJDPA federal law, they need a lot more. The costs become pretty high pretty quick. And so I would just say, this ends up being more a choice of, it ends up not costing as much as people think it costs Although I know it is very hard to wrap your head around that until you actually do it. But I can show you data after data after data in states that have done this, and their costs were not even a fraction. As a matter of fact, in Connecticut, their costs went down by $2 million after making this change. And I do want to point out to the Vice Chairman, thank you for, I was not trying to any way, shape or form vilify the DAs. I was trying to articulate the fact that when it's automatically, when these statutes exist that automatically exclude children from the adult system, that ties their hands too, right? If it's in a juvenile court and there is a certification hearing, that also does give the DAs an opportunity to look at the full picture as well and make decisions that are based on something more than the crisis of the time between arrest and when they have to charge. So I agree with you.
Thank you. Senator Hannan, go ahead.
Thank you. And I apologize. I just got called down to, I have to go down to another office for another meeting here. So I want to get this in real quick. Ms. Mistrett had mentioned that she doesn't know what the numbers are here. And I think in our last meeting, we were promised some numbers. Did we get any of those numbers, I think, from the DA's office? Because that's one of the things I recall that they were going to supply to us. Maybe Mr. Guinan knows.
Madam Chair, yeah, for the record, Patrick Guinan, Ms. Duffy did supply those numbers, and I have a PDF. I think I sent it to the committee members, but I'll resend it right now for the members.
Thank you very much. I probably just missed it. I tried to go over everything yesterday and didn't get to everything. Thank you.
Yep, my pleasure.
Yeah. Members, any other questions before we move on to the next presenter under agenda item 6? Okay, I am seeing none. So I thank you ladies for your presentation. It's always interesting and impactful and meaningful, and I appreciate that. Thank you so much. And I'll just ask out because as we hear the next presenter, there may be questions for you all as well. So thank you. So with that, we will move on to the representatives from the Division of Child and Family Services.
Good morning, this is Ross Armstrong with the Division of Child and Family Services, and thank you for having this important conversation today. I don't have a lengthy presentation and mostly is kind of a summary of some of the things we've heard before. I know there are also county representatives to talk about this topic from their point of view. And so I would just start first by noting that, there's the legal authority, which has been talked about today, is important to keep in mind, including the Juvenile Justice Delinquency Prevention Act, the Prison Rape Elimination Act. And then for us, all of our juvenile process is outlined in Title V of the Nevada Revised Statute, and then the adult process is outlined in Title 14 of the Nevada Revised Statute. I don't have confidence that an MOU would be sufficient for us to meet the requirements of those federal oversight laws. And so I think a more robust statutory change would get us to the right place. There are 5 main factors, I think, when this committee is considering this policy change. The first would be location. Where would these youth be placed within the juvenile justice system? If we're talking about post-conviction, only one of our 3 facilities is physically secure. So only one of our 3 DCFS facilities has a fence around it. And so that would be Summit View Youth Center, and probably the only suitable facility for this type of youth. And then some questions about the staffing. So is it Nevada Department of Corrections folks that would come in and operate that part of the facility, or would it be Division of Child and Family Services? Because it's at a juvenile facility, they would need to meet those PREA ratios of 1:8 during the day and 1:16 at night, which is very different than the regular NDOC staffing ratios. Services, how those would come into play. I think that our the folks in Lovelock do a great job with what they have. One of the issues that we have is for our kids in DCFS custody, there's an incentive to go to school and to participate and engage in services because that will accelerate your return home. That is not the case for those that are convicted in the adult system. At least, you can get some time for good behavior and those types of credits. But I know that the Lovelock folks experience just resistance to those youth wanting to go to school because in their mind, what's the point? I have a certain time I have to serve, and so I don't, I don't want to engage in that. I'm just going to, essentially do my time. And then the funding piece, how that funding of services and staffing works. So some key things about the sight and sound separation that is in the JJDPA, the Juvenile Justice Delinquency Prevention Act, and then it's touched on in PREA, at least in adult facilities, is there are a number of factors that they would look at to determine that the two types of inmates are in two separate programs. And part of this, I think really part of our struggle in tackling this population is that Nevada actually has no real definition of a youthful inmate in terms of someone who is convicted in the adult system but is not of adult age. We don't have a structure around what that looks like. I think that could be helpful as this committee considers NRS changes. I do think that there is a great, it's important to also note some of the differences in just governmental structure. So we heard about California. So let me back up a little bit. There are three main structures for juvenile justice services in the country. One is where the juvenile justice services are housed within the agency that does adult corrections. The second one is a totally independent type of agency. And then the third one is it can be housed in the Department of Health and Human Services. So California mirrors that first model where it's actually the Department of Corrections that runs juvenile justice. You may have noted that during the economic downturn in California, they're actually shutting all of their Department of Corrections facilities for juveniles and leaving it to the counties to address those needs. Oregon has an independent Oregon Youth Authority, a lot more flexibility and jurisdictional range there, as indicated in that chart. And then, of course, Nevada is housed within the Department of Health and Human Services. I think there are pros and cons to each of those structures, but they're important to keep in mind as we consider the issue of housing. And so, to summarize, I think it is a great idea to figure out how we can serve these youth best. I think, there are some that are sentenced for a short period and some that are for a very long period. We would take probably different approaches to those two. But from our perspective, we would be happy to work with this committee's counsel on any sort of NRS changes to make sure we're staying within the bounds of the JJDPA, PREA, and then our Title V and Title 14 within our NRS. So that is all I have. I think, I don't know, Chair, if you want to pass it to the county juvenile justice agencies, and then we can answer questions as a panel, or however you want to go forward would work with me.
Yes, thank you so much. I would like to go ahead and pass it to our county, and then we can wrap up the questions at the end. So I believe we have Mr. Cervantes and Mr. Martin from Clark and Washoe County. If you could join us.
Good morning. Frank Cervantes, Director, Washoe County Juvenile Services, and I have with me.
Hi, good morning. Christina Coles, Division Director, Washoe County Juvenile Services. Liz Flores, Division Director with Juvenile Services over probation.
So great conversation. First of all, so one of the questions that was posed is, can the county juvenile detention facilities serve as a holding center for some of the youth that are in the Lovelock Correctional Center? And we've had this discussion, and I said this before, we had a Supreme Court subcommittee on juvenile justice that really did a study on overarchingly blended sentencing. And part of that was regionalization of correctional beds for juveniles and the housing of youthful offenders in the adult correctional system. And so the conversation, usually goes back to one of the predominant features of juvenile justice administration is this low risk, high risk concept. And so we try to really match the kids' levels of needs and risk. And the short-term detention centers, at least speaking for Washoe County, is designed for young people who are pending further disposition in the juvenile system or awaiting transfer to another facility such as mental health or one of the state correctional facilities that Ross is authorizing. So, we've talked to both Jack down south, and I've talked to Ross. In answering the big question, it has some problematic logistics to use the Jan Evans Juvenile Detention Center for long-term housing needs for youth that are placed out in Lovelock. We don't have the programming that's really set up for long-term housing, and it causes some issues because, you know, the kids that we have really good education, we have all the medical needs, and we can provide that to whoever's in the facility. Where we really run into a problem is the long-term program. You know, some of the youth that are being transitioned ultimately upon age majority into the correctional system don't have as much to lose. They have much more severe offenses. So really it's how to blend that population with our current population. Now we can do that for short periods of time, and we do that now with youth who are pending the proceedings in the adult cert, and usually the public defender's office will file a motion to have those kids held here pending the resolution of their certification cases. And we can manage to do that because it's much more difficult for the sheriff's office to provide those services, as you previously discussed from your earlier panelist about education and medical services for youth. We can do that much more proficiently because that's our business. But longer term is where we run into the issues because our systems really weren't designed for that long-term care. And so I'm just going to leave it at that because I think the discussion will probably promote some questions. So if I can, at this point, I'd like to throw it down to Mr. Martin, Clark County.
Thank you. Mr. Martin, if you're there, please start. Good morning.
Yeah, good morning, and thank you, Madam Chair and members of the committee for the opportunity to share my thoughts today. My name is Jack Martin. I'm the director of the Clark County Department of Juvenile Justice Services down here in Las Vegas. The biggest issue, and I agree and I disagree. I'm always careful whenever we compare anything to California. Having left the California system after many, many years of working in it, there's a lot of different mechanisms there that weren't exactly shared transparently. I mean, the system in California can house children up to 24. That's not part of our world. Direct transfers or direct files and certifications have been kind of bled and bounced around in between, intermingling these conversations. They're two very separate processes that occur. The direct file is obviously something that we in juvenile justice have zero influence on now of any kind. That is murder, attempt murder, aggravated sexual assault. Those three, we call them the big three. Those are automatically direct filed. Those children have no jurisdictional. I might hold that child for one night or until their first hearing. Our average length of stay here in Clark County is 18 days. For an actual Clark County child, that's about 11 days. For a child that's pending placement or pending going to the state, those numbers go up exponentially, which makes it about 18 days. In reading the documents that were submitted by the Nevada Department of Corrections, their average length of stay is 299 days. There's about 14 youth, about 299 days. I'm going to assume the majority of those children are coming from Clark County. I'm not going to disagree the value of housing children with other children. I'm not even going to touch that because there's been quantitative multitudes of research that have been done to demonstrate that it is. But I am always cautious whenever we talk about a state function and discussing it at the local level. There's a history of things being pushed further and further back to the county. I mean, right now we're watching it with DCFS limiting their beds at the state level of DCFS right now, which creates a backlog of children within the county system. So within our detention center on any given day, I've got between 12 and 18 children that are pending placement at the state. Now you've added another 14 children. So to say that there are no costs associated with it or very little costs, I would disagree with that. I would love to have a deeper dive into those costs. I just don't believe that's a realistic expectation to say there are no costs. And then to say I'm leaving from an 18 bed average length of stay to 299. I have no vocational rehabilitation stuff here. I have no long-term planning. I don't have the mental health or clinical staff set up to establish long-term care for children. I don't have the medical plans to deal with long-term medical needs of children that are going to be housed here longer. I mean, there are a lot of hidden costs there. I mean, so like I hate to say it, if you want to drive a nice car, you got to pay for it. And I don't disagree with the validity of housing children. But I do disagree, wholeheartedly that the costs are not going to be, there's going to be limited costs or even less costs. This MOU that would have to be between Clark County and the state corrections we'd have to really explore what those costs were, so there wouldn't have unintended consequences on children that are currently pending placement at the state already. I mean, there's a lot of unintended consequences I think that would come into play here. Not to say they couldn't be worked out. I absolutely believe they could. We've got lots of smart people here in the state. We could figure all this stuff out, but there is going to be a cost associated with it. I think that was all my thoughts, Madam Chair.
Thank you. Members, questions for these three presenters? I do have a question. And for the counties and Mr. Ross, Director Ross, what would the impact be to the system as a whole if we were to consider allowing the jurisdiction to be extended for that youthful offender and the need to define the youthful offender to include extending up to the age of 21 and possibly 24? What would that look like, and what would it require to retrofit our county facilities or state facilities to accommodate that? And anyone who wants to jump in, please feel free.
This is Jack Martin for the record, and thank you for the question. I would need to look before I could answer, and I would want to answer this intelligently because I think it's a great question. I would need to look at CCDC, because we're in the business of collecting data on kids under 18 or 18 and under. I would need to look at what CCDC is housing in terms of kids that were 21 and under, 24 and under. I need to get a better feel of the numbers that are there. I can tell you for a day, it's about $290 a day per child for in-care custody at the 1-to-8 staffing ratio. So, I mean, once we get those raw numbers, we can kind of extrapolate that out. In terms of actual housing, I'm going to assume from 21 and for 24 and 21, we can do two different, workups if CCDC would be willing to share the data with us. I think the biggest issue there would be physical plant. My physical plant here on my detention is not. I heard Ms. Wellborn mention earlier, like LME, large muscle exercise. I do not have a large facility, with a large baseball field or a football field or something like that. I don't have an open track. Before I started this career, I did run youth correctional facilities for many, many years in California, Arizona, and Hawaii. So I'm very familiar with juvenile corrections and what needs to be, what a good quality system looks like. So, I mean, I would need time to quantify that specifically. And I think it's going up to 24 that's going to be a heavy price tag. 21, I'd be interested to know just what the raw numbers were so I could give you an accurate answer.
This is Ross, and I would echo what Mr. Martin said in terms of the kind of the big ticket item would be physical infrastructure. The Summit View Youth Center facility has 96 beds. It doesn't have all those other, I don't think there's enough space there to run a quality program and safely with actually 96 people on the campus. And so it would also depend on 21 and 24. So we could certainly, if we were able to get the data from the Department of Corrections and our adult counterparts, that would help us make a more informed decision in terms of the actual impact. As also Mr. Martin indicated, we had a budget reduction that reduced our beds substantially. We have 138 kids in care right now across the state. But that physical infrastructure piece is going to be the biggest. Currently, Title V, which governs us, we have to release the child at age 20. So we rarely have 19-year-olds still in the facilities. Usually they're working out in parole and are working towards re-entry. But currently the law says we cannot have any child 20 years or older in our facilities.
I have a question, Vice Chair.
Go ahead. Assemblywoman Torres.
Thank you, Vice Chair. And Mr. Martin, I know a couple meetings ago, you had spoken about there were several girls that were certified, and we had discussed that they were going to be staying here in Nevada, and that we were committed to ensuring that they were kept here in Nevada. And so I just wanted to follow up on that while we have you here and kind of see what that certification process ended up looking like for those young ladies.
Thank you for the question. Through you, with a Chairwoman Monroe Moreno. I have the hardest time with your name, and I apologize for that.
You can go directly to the member. You can go directly to.
I appreciate that. Thank you, Assemblywoman Torres, for the question. The reality for us is the couple of women or young ladies that we've kept in our system here have been one doozies. You know what I mean? There hasn't been a policy discussion. There hasn't been a change. What we found out, what I had learned, is that a couple of these young ladies were going to be kept in isolation for extended periods of time because of the PREA restrictions at the adult level. And I said, and we could afford to take one or two young ladies. So we took them and we housed them. There was no contract that was entered into. It was all house them until they turn 18. At that point, we were pretty successful with a couple of those girls, obviously keeping them, you know, kids don't fix themselves, right? So that was not a formal agreement. We haven't been reached out to or contacted about any other since, to my knowledge. So to give you an actual specific process in which we do this, it's really not. It's more of a handshake and talking and making sure that those girls aren't isolated unduly, if that makes sense.
And I appreciate that. But I had also heard that a number of those girls were transferred over. So I was just wondering if we could speak to what that transfer process looks like after the young women have been certified.
Once again, Jack Martin, for the record, to be honest with you, that transfer process was not Clark County. That was not Clark County that did that. That was the Nevada Department of Corrections, I believe. And to be honest with you, we had no idea where the child was going. I was under the impression with one of the children that they were going home, and then found out later on that they weren't. They were sent to Arizona. So we're in that process. We didn't have they were not adjudicated into our care and custody. We were just holding them as a courtesy hold for their friend and providing for our friend agency and providing some level of supervision and programming.
And could you explain a little bit, like structurally and like statutorily specifically, why something like that might occur?
Can you clarify that for me? What are you trying to get at? I'm sorry, I'm not understanding.
All right, gonna hit unmute. So you had mentioned that you had made this agreement, but then they were transferred over, and that this kind of went on without your knowledge. So I'm just wondering why something like that might occur, that they're allowed to stay and then they're moved and transferred over to another state. And essentially, I think that's going to make it extremely challenging for those young women and their families to continue any type of relationship or socialization. So I'm just wondering if we could explain like why those transfers occur, these interstate transfers for young women.
My understanding is, and you would need an NDOC representative to give you so if I'm incorrect, please somebody correct me if I'm wrong. My understanding is that NDOC did not have the ability to house those young females on their campuses without having to isolate them due to PREA. So that, you know, because that was the mechanism, I courtesy housed them upon their turning 18. You know, we don't house children over 18 at that point, or we do house them, but in kind of limited perspectives. The child had completed all the things that we were going to complete here. Like I said, you know, the mechanisms of it, of why they transferred or how they transferred her, I don't know. I wasn't a part of that conversation. I just know that we held one girl for almost a year and a half, almost. It might even be longer than that. I'd have to go back and check. It's been a couple of years now. I wish I could be more helpful.
Assemblywoman Torres.
No, that answered my question. Thank you, Vice Chair.
Members, any other questions? So I would be interested in finding out what what that expense would be if the age was expanded to 21. I think that would be helpful for the committee. I don't believe it's the committee's intention or anyone's intention to require our county facilities or state to force anything upon them without having the adequate funding available to make this happen. So I would be interested in finding out what that was. So if you could all look into that and get that to our committee policy analysts, they could share it with the committee as a whole. I think that would be extremely helpful as we move forward in discussing this. There was one other question, and it kind of may have to follow up on that.
This is Frank Cervantes, Washoe County.
Go ahead.
We're just looking for some clarification. I heard a couple of things through the discussion. One I heard was looking at young folks up to age 24. I heard looking at youthful offenders up to 21. Are we talking about the kids that are going through the certification process, or moving that age of jurisdiction in whole up to age 21?
I would like to see moving the age of whole up to 21. I think in our conversation today, 24 would be problematic for our facilities, but I would like to know what it would, how it would look to move that number to 21. And in response to Assemblywoman Torres's question, we currently have an interstate compact where our female youth offenders are moved out of state because of the cost that it incurs to the state of Nevada to have a facility built just for one or two females. And currently, I believe we only have one female that's currently out of state. And the cost of that is kind of a wash because of the interstate compact. We pay nothing for that female to be housed in the Arizona facility. And I had asked a question at the last meeting if it was a privately run facility. It's a state-run facility, not a private-run facility. And the state of Arizona has a person that's here, so there's no financial fees incurred to us. So just wanted to let you know that. And for Mr. Cervantes, it would be granting the juvenile courts the ability to retain jurisdiction of our youthful offenders if needed up to age 21, and then and what that would look like at 24, I think would be helpful for this committee to have both of that, if that makes sense.
Again, Frank Cervantes for the record. In the juvenile justice system now, we can retain jurisdiction on kids that we have in the probation system and under the court's jurisdiction now up until age 21. And so I'm just making sure that, are we talking about new offenses so that a 20-year-old that is typically going into the adult system on a new charge, would we also be looking at bringing those kids into the system or adults into the juvenile system, or the ones that we currently have under jurisdiction?
And that's a really good question. I think that would be up to the courts. For the new offenders, I think that would be up to the courts. But if a juvenile enters our system under the age of 18 and allowing them to stay in our system up until 24 was more at the direction that I was leaning to find that information. Does that make sense?
Yes, it does. Thank you.
Madam Chair, with your permission, just one more clarifying point. I mean, so I would like to also poll, so maintaining the jurisdiction until they turn 24, maintaining jurisdiction until they're 21, those are two separate pieces. But also looking at, I was going to reach out to CCDC and NDOC and see how many young people age 18 to 21 they have in their current custody, and also 18 to 24 in their current custody, just to understand the totality, you know, so we always have scope creep in everything we do in government, right? So just to make sure we cover all three of those bases, does that seem appropriate?
That does seem appropriate, Mr. Martin. I appreciate that. Thank you. Yes.
Thank you, Ms.
Members, any other questions? All right, seeing none, this has been a great conversation. I thank you all for your presentation and your patience with us as we go through the questions and clarifying information. I know we're all here working to do the best that we can for the children in our community, and I truly appreciate your continued work and what you're doing with our children throughout the state, and your work with our committee. So I believe that brings us up to the next item on our agenda, and that would be public comment. So I would ask our broadcast staff and everyone to give us just a few minutes to go to public comment to see if there's anyone waiting to make comment.
Vice Chairman Moreno, the public line is open and working, but there are no callers at this time.
Thank you so much for that. So seeing no public comment, I would like to thank you all for joining us. Thank everyone for the presentations that you presented today and all the great information. And that brings us to the last item on our agenda, and that is adjournment. So I wish you all a wonderful day. This meeting is adjourned.